To continue on with the findings that were found by Judge Kim Cooks, the court finds that James' first grade teacher described him as the happiest kid in the class. Well, that's wonderful. James is attending school as a girl, remember, under the name Luna, wearing dresses provided and dressed by the mom. That's why the mom does not want the father to attend any school activities, because the father takes the boy out as a boy. Yeah, imagine that, huh? The court finds that James' first grade teacher stated that James came to school with makeup on a couple of times. Okay? The mother is obviously, or the sisters, I don't know who, but somebody's putting makeup on James because James is only a first grader. I don't know, maybe first grader these days know how to put on makeup, I don't know, but I think at that age, if it were up to me, I probably would have somebody putting makeup on me. So probably the mother or a sister, something like that. The court also found that Diane Zilka from the Family Court Services stated that Luna, now again, Luna is a made-up name. James is the real name. Luna is a fictional name. But the court finds that Diane Zilka from the Family Court Services stated that Luna reported that she, Luna and she, again, fake people, prefers to be called Luna rather than James, though she is comfortable with both names. This is significant in that she doesn't identify only with one gender, but there's some fluidity. And once again, Judge Kim Cooks, I'd like to remind you that as a legal document, you should be referring to James with his legal name and with his medical biological sex. James is not a girl. James is not a Luna. I guess for shorthand you might say this, but James is a boy, and he should be referred to with proper pronouns reflecting his maleness in legal court documents. My opinion. The court also finds that Dr. Abe Tomatis stated that he has not seen clinically significant distress with James. This is very important because, once again, there is no gender dysphoria. If you have no distress, there is no gender dysphoria. You must have distress, open distress, a lot of distress, to have gender dysphoria, whatever this whole gender dysphoria thing means. James did not have it. There is no gender dysphoria. So now we're going to go on to the father, what the court found with regard to the father. Judge Kim Cooks found this. The court finds that the father answered when asked, "Mr. Younger, you're the father of these two children, Luna and Jude, right?" And he answered, "Yes, ma'am." I don't remember that taking place like that. Perhaps it did. If that is the case, he did answer yes, because there was one time that they caught him that he used the female pronoun that kind of tricked him into it. Well, I just noticed you called her, that you just called James a her. Something along those lines. So evidently the father must have done that according to the transcript, I guess. I don't know. I'd have to look back and see from my own notes. I don't remember this, but regardless, he knew who was being referred to. Number 32, the court finds that the father stated that he thinks it is more important for the public to know what's going on with the court than have his child live a private life. And I actually agree very much with Mr. Younger. When I first heard about this case, I was appalled that our courts would allow such a thing to happen to children, that they would allow a mother or a father, whatever the case may be, this is not pick on mother, it's whoever has the child, whoever is doing this, that they would allow that child to be abused in such a manner as it would appear he's being abused right now. That there would be somebody that could brainwash the child into saying, "Boy, you're a girl," or "Girl, you're a boy," or "I'm going to give you a new name," or "James is not your name, Luna is your name." Something like this. The courts are permitting this. The courts are giving orders that a father is not allowed to tell his son that he is a boy. Judge Scott, Associate Judge Scott Beecham, B-E-A-U-C-H-A-M-P, spells like Beauchamp. His name is Beecham. That was an order given by Associate Judge Scott Beecham. I think it's important to see what kind of corruption dwells in this swamp called family courts. And I completely agree with Mr. Younger. I was so shocked about this that I thought this had got to be a story from the National Enquirer on steroids. I tried to make contact with the church. I tried to make contact with various people. Eventually somebody met him and put us in contact with each other. I went to his house to ask questions, to interview him in person, to say there's no possible way this could be taking place. It was taking place. And that's why I felt that this trial was the most important trial in the state of Texas. I stand completely with Mr. Younger. Because of the nature of what is going on here and the ramifications that a case like this could have to your children, your grandchildren, apart from your will, apart from your knowledge perhaps, even in spite of your protest, this was a very important issue. It was not Mr. Younger that made this whole thing public initially. It was actually Dr. Georgelis. Dr. Georgelis had pictures of James as both a boy and a girl, both on her Facebook page and on her medical professional page. Mr. Younger had to respond somehow, and that's why he brought awareness of this case. And I, for one, am very thankful that he did. Once again, I looked at this as being the most important case in the state of Texas, if not the entire country, that took place this year. Number 33, the court finds that the father stated he is an Orthodox Christian and his church is completely opposed to teachings as it relates to the position on transgender. And for Eric Treen, the special counsel for the Office of the Attorney General on the U.S. level, this is a case I think you should be looking at. Even though this is a state issue, this is happening in every single state. This is why when I talked with you about the issue in Pennsylvania regarding the no-fault divorce issue, this issue takes place in every single case. The family law associations have been making state-by-state efforts since the 1970s to get laws put into place in every single state. They did not do it on a national level, but for all intents and purposes, it is imposed upon a nation, but at a state level. And almost every single state has something that would allow this type of atrocity to take place against a person's religious convictions, against the teaching of the Orthodox Church. So had the mother been able to win in this, it would have said, church teachings, we don't care what your church teaches. It's whatever we as the court thinks that we want this person to do and not do. And in the case of Mr. Younger, who was an Orthodox Christian, his church teachings would have been violated and were being violated in the process that they were undergoing at this point in time. Number 34, the court finds that the father stated he started seeing James wearing a rag on his head and calling himself a girl a couple of months after his 3rd birthday. This has been going on for a long time. Number 35, the court finds that the father stated he took pictures of James in girl clothes while at his house. Number 36, the court finds that the father stated there was a time when the child put on a dress while with his father, but he still called himself James. Number 37, the court finds that the father has acquiesced to James attending kindergarten, 1st grade, and now 2nd grade as a girl, while the mother has pushed the girl issue full force. The father really didn't have much say in the matter. In fact, one of the mother's attorneys, a previous attorney, threatened the father with a lawsuit should he take certain action to try to stop what the mother was doing with James. Number 38, the court finds that the father repeatedly stated he is not in court voluntarily. He is here to do this trial based on his former wife's request to modify the prior order. So once again, even though these attorneys for the mother wanted to try to smear Mr. Younger, it was their client that caused these problems. It was her modification. He did not want to be in court. She wanted the court to allow her to do whatever she wanted to and to have the full power of the court behind her. Number 39, the court finds that the father did not file any temporary restraining order or modification when James began kindergarten as a girl. Why should you have to, is the question that I have. Why should a father have to file an order with the court to have the court say, mother, you can't enroll James as a girl into kindergarten? Number 40. Once again, the court finds the father did not file any temporary restraining order or modification when James began 1st grade as a girl. Number 41, the court finds that the father did not file any temporary restraining order or modification when James began 2nd grade as a girl. Number 42, the court finds that the father admitted when asked, you heard Diane Zilka testify that you should get counseling with your children, right? The answer is, she wanted family counseling, yes. Question, all right, you haven't done that, is that correct? And the answer is no. So here is a social worker, a family court services worker, who gets to order the father to what to do. the father evidently did not obey her wishes, and this is now a finding of fact. Number 43, the court finds that the father has not done any family counseling with the children, but admits that it is of the essence of raising my children that family counseling be involved. Part of the reason the father did not seek to do the family counseling with the people that were recommended was because they were embracing the LGBTQ ideology. He wanted to find somebody who was not doctor shopped or counsel shopped, somebody who actually came from the same type of a background that he did, not somebody who was adhering to and buying into an ideology. Number 44, the court finds that the father stated that his wait-and-see approach means until Luna is an adult. And again, I don't remember where this Luna is coming in from. I don't remember him calling James Luna. And as a legal document, it would seem appropriate for me that the judge should actually use James' legal name instead of this fictional made-up name, Luna, in referring to different statements. So the court finds that the father stated that his wait-and-see approach means waiting until James is an adult. And that is actually correct, and that's actually in accordance with what Dr. Stephen Levin said later on, which I'll get to in just a moment. Number 45, the court finds that the father, knowing that the trial was coming up, thought it was appropriate to invite a news reporter from LifeSite News into his home to interview his children for a news story. And as well, I would support Mr. Younger in what he did. I interviewed him. I did what I could to bring the story forth. But LifeSite has a much wider circulation, a much wider readership. They've got much more influence. I know the lady who actually went into the home, and I think that she did a wonderful job. Had it not been for her, I believe that the nation would not know about this outrageous action taking place in the state, that almost took place in the state of Texas. And not just in our nation, but throughout other countries. Just yesterday, in fact, a reporter from Poland talked to me, interviewed me regarding what took place in the Save James situation. So this is not just an issue that's taking place in the state of Texas and in our country. Other countries now know that in the state of Texas, there is a doctor, pediatrician, who wanted to socially affirm her son as a woman, as a girl, in preparation for possible chemical puberty blockers, sex change hormones, and surgical mutilation in the future. This is known worldwide. And again, with LifeSite News, and let me also say this about LifeSite News. LifeSite News was there Thursday for the final hearing for the order that Judge Kim Cooks was going to give, and the person who was from LifeSite News was also barred from the courtroom. So I wasn't the only one barred from the courtroom. She was a legitimate reporter, and even Kim Cooks, in her findings of fact here, knew that LifeSite News came into Mr. Younger's home. She knew that this person was a reporter, and yet she was barred from entering the courtroom with the rest of the media. That's why I say that perhaps there was a bit of retaliation performed by Judge Kim Cooks against the media, allowing only favorable media into the courtroom and not media that caused this ruckus, because they were reporting accurately and honestly about what was taking place. Number 46, the court finds that no Texas judge or Texas court has ordered the chemical castration, puberty blockers, hormone blockers, or any transgender reassignment surgery on James to become a female. Well, this would not happen at age 7. They were talking about taking him in for this age 8 or 9. That is in the evidence that was presented. They didn't have to have anything there right now. Nobody was expecting an order to be here yet. What was taking place was all of the preparations so that, in accordance with Dr. Rebecca Orr's recommendation, that at age 8 or 9, that James would come back in and they would evaluate him for possible transition, a boy. Dr. Rebecca Orr, the founder of Dallas Rainbow Counseling, was going to send James to the Genesis Clinic. The Genesis Clinic is a clinic out of the Children's Medical Hospital in Dallas, Texas, and they help LGBT, especially the transgender people, affirm themselves, and also can prepare them for medical transition to change genders. Again, it will never change their chromosomes. At the very core, there will always be a boy, there will always be a girl, but this is what Children's Medical Center of Dallas, Texas has a special clinic called the Genesis Clinic. and Rebecca Orr was referring James to that clinic, was planning to refer James to that clinic for future preparation to change his sex. Number 47, the court finds that the father may have initially had valid concerns regarding his children and the mother making crucial decisions without his input. You think? However, the court finds that the father finds comfort in public controversy and attention surrounded by the use of unfounded facts and is thus motivated by financial gain of approximately $139,000 he has received at the cost of the protection and privacy of his children. Is this really a fact? Or is this a judge trying to read a motive into Mr. Younger? Nowhere was this actually ascertained as a fact, and yet Judge Kim Cooks is stating that this is a fact. Somehow Judge Kim Cooks knows the motivation behind what Mr. Younger was doing. Somehow, as a finding of fact, Judge Kim Cooks gets to state that the father finds comfort in public controversy and attention. Nobody wants to be involved in this. And the reality is, in my opinion, it was because of a previous order that Judge Kim Cooks made granting the mother the exclusive right to the medical decisions that caused this controversy. So Judge Kim Cooks should really revise this as the findings of fact and say, I, Judge Kim Cooks, caused this problem because of a very bad order that I wrote, favoring the mother unfavorably and giving the father little right to actually veto these things. That's what Kim Cooks ought to be saying. Not this nonsense here about a finding of fact that the father finds comfort in public controversy. That is not a finding of fact. That is a rendering of an opinion. And there's a big difference between the two. Regarding the financial gain of approximately $139,000, again, $16,000 of that was given for him to actually live off of. And the rest was mostly done for legal fees and expenses taking care of James and other such things, James and Jude and other such things. So this idea that somehow that Judge Kim Cooks gets to insinuate that the father enriched himself is motivated by the financial gain of approximately $139,000, I think that Judge Kim Cooks should apologize for this so-called finding of fact. I find it also very interesting that in this finding of fact by Judge Kim Cooks, that she refers to the father finds comfort in public controversy and attention surrounded by the use of unfounded facts. My comment would be, Judge Kim Cooks, that this seems to be an unfounded fact and that somehow you seem to not be able to distinguish between an opinion and facts. I did not come to the same conclusion of fact that you did. In other words, my opinion, my perspective differed from yours. I will not call my opinion a fact, such as you can call yours. This is atrocious what you tried to do here in smearing the father, and I think personally that you owe the father a public apology for using this type of an opinion of yours to smear him, and it's not a fact, it is your opinion. Anyway, up to this point, I've gone through the 48 findings of fact that the Judge Kim Cooks has found regarding this trial. There are still another 20 to go. I probably will get to them another day, and I will continue on later, starting with fact number 49, what the court found regarding Dr. Stephen Levin. Thank you very much.